Welcome to NCA with AI. Today's explainer is all about tackling an absolute beast of a test, the NCA Foundations of Canadian Law exam. We're also going to dive deep into the massive 1988 Quebec secession case. I'm going to break this all down super simply, almost like we're just grabbing a coffee and talking it out, so absolutely anyone can grasp it. Let's get right into it. Okay, so here's our game plan. We're going to decode the exam mindset first, figure out the art of critical analysis, look at the unwritten rules of Canada through Quebec's breakaway attempt, hit Indigenous rights, and then finally lock down your actual exam strategy. So, Section 1, Decoding the Foundations exam. Let's figure out why this specific test freaks so many law students out. I mean, ask yourself honestly right now, are you actually prepared for this? Because treating the Foundations exam like a standard law school memory test is pretty much a guaranteed recipe for failure. A lot of people walk into this thinking, oh, I can just memorize cases and rules. But no, this exam is testing your general, broad knowledge of Canadian law across the board. Think of the Foundations exam like a giant puzzle. On a normal law exam, you just memorize things. Apply a strict IRAC formula, issue rule analysis conclusion, and you're good. The Foundations, it's all about connecting wild, seemingly unrelated concepts. The examiner might suddenly throw a question at you that mixes constitutional law with admin law. It's totally testing your ability to see the big picture and make those connections dynamically, rather than just spitting out a formula. Moving on to Section 2, the art of critical analysis. This is literally the single most important skill you need to survive this syllabus. The prompt always asks something along the lines of, do I understand the articles and do I have a personal opinion? Listen, the examiners do not want you to just act like a parrot and repeat facts from those massive 40-page assigned articles. They want to know your personal take. Are you just passively absorbing info, or are you actually analyzing it? Having your own viewpoint and backing it up is absolutely crucial here. So, how do you handle all those crazy readings? Instead of drowning in hundreds of pages, just use these 4 super simple steps to summarize every article into short, punchy notes. First, what's the topic? Second, what exactly is the author's opinion? Third, and this is the big one, what is your opinion on what they just said? And fourth, wrap it up with a quick conclusion. If you do this, you can just quickly grab these insights on exam day without frantically flipping through giant stacks of paper. All right, Section 3, Canadian Constitutional Pillars. This is where we hit the heavy substantive law and the unwritten rules that keep Canada from falling apart. First up, you have to wrap your head around constitutional supremacy. Basically, the Constitution is the absolute, unquestioned boss in Canada. It's the ultimate rulebook. Even the government can't just be like, hey, we're going to override this with a regular law because it's convenient for us today. Nope, everything has to bow to the Constitution. Let's apply that to the super famous 1988 reference re Secession of Quebec case. To explain this simply, imagine you're sharing an apartment with some roommates, right? And one day, one roommate wakes up, packs their bags, and says, I'm taking my bedroom, my walls, my floor, and I'm legally severing myself from this lease entirely on my own. That's kind of what happened here. Quebec wanted to split as a unilateral state from Canada. They literally just wanted to bounce. So naturally, this goes straight to the Supreme Court. And the court basically said, yeah, no, you can't just bounce unilaterally. It's unconstitutional. You can't just take your room and leave the apartment complex without talking to anyone. But, and this is a massive caveat, they added that if a province clearly shows a democratic desire to secede, it imposes a reciprocal obligation on the rest of Canada to actually sit down and negotiate. So you can't ignore them, but they also can't just walk out the door without a massive legal conversation. To explain exactly why Quebec couldn't just walk away, the court mapped out 4 unwritten principles of the Constitution. Think of these as the invisible glue operating the entire country. Federalism means provinces have autonomy, but hey, we're still one nation. Democracy means the majority has a voice. Constitutionalism and the rule of law mean we all play by the rules. And respect for minorities ensures the majority can't just trample the vulnerable guys. These unwritten rules, they are just as powerful as the written ones. Okay, Section 4, Indigenous Peoples and Law. This is another massive chunk of your exam that you absolutely have to master. Listen, Indigenous law in Canada has evolved incredibly fast, and you really need to track this roadmap. Watch how it moved from just basic recognition of Aboriginal rights back in the 1990 Sparrow case to establishing a real test for Aboriginal title in 2014, all the way to 2024, where the Supreme Court fully affirmed the inherent right of Indigenous self-government over child and family services. Seeing how fast this progressed is key to understanding where the law actually sits today. Now, here is a huge exam trap for you. You need to know the exact moment the government is legally required to consult Indigenous groups before acting. It's not a polite suggestion, okay? It's a strict constitutional duty. But when does that alarm bell actually ring? It all boils down to 3 triggers. First, if the Crown, which is just a fancy word for the government, has real or even just constructive knowledge of a potential or recognized right. Second, the government is contemplating doing some sort of action. And third, that action might negatively impact that right. If those 3 things are there, boom, the duty to consult is triggered. It's really that simple, but you got to apply it carefully to whatever crazy facts the exam gives you. Finally, Section 5. Let's talk about mastering the exam format, because knowing all this law is really only half the battle. When you finally sit down for this NCA exam, you have to be ready to adapt on the fly. A rigid one-size-fits-all approach, like a standard IRAC, is literally going to sink you here. The examiners want to see dynamic, flexible answers that actually address whatever specific prompt they've thrown at you, whether you're drafting a legal memo, writing an essay, or just doing a quick critical analysis. Depending on the question, you've got to flexibly mix and match your structure to best showcase your critical analysis and your own personal opinion. You might start with facts, then the issue, then your conclusion, and finally your discussion. Or you might just lead with the issue, drop a brief answer right away, and then dive into the facts. There isn't one perfect magical format, as long as your structure clearly presents your reasoning and your point of view. And please, listen to me on this one. Do not forget to casually mention the author if you quote an article. There are no strict citation styles required for this. You definitely don't need perfect Blue Book or Oscilla formatting. But if you drop a direct quote from an assigned reading and don't say who wrote it, that is a fast track to failing for plagiarism. Just write something like, as author X stated, and you are totally fine. So, learn the rules, grasp the complexities of the Quebec case, memorize those consultation triggers, but above all else, form your own opinion. Because these unwritten rules, they are constantly being tested. What happens when the next province or nation decides to push the boundaries? The examiner is literally begging to see what you think. Think about it. See you next time.